Good evening. I'm Jamal Shaheen from the Institute for European Studies here upstairs at the Vrije Universiteit Brussels, and also assistant professor in European Studies at the University of Amsterdam in the Netherlands. We are here in the first, or to open up a lecture series on the EU's performance in international institutions. This is the first of 9 events, which are spread out over the entire semester. So there are a couple of events in the next 2 weeks, then there's a gap, and then there's a few more events that cover more substantive issues. All are mentioned in the program that's available behind you. We're going into trade, climate, internet governance, and migration issues. And those will be taking place over the entire semester. All of the events have something in common, even though they cover different policy areas, in that they're looking at the role of the EU in international institutions, and particularly focusing on how the EU works within these institutions, and so on and so forth. Tonight, we're opening up the lecture series with a discussion on the development of the research agenda in this field. Unfortunately, Megan D, who's also been doing quite a lot of work on EU performance in international institutions, couldn't make it. She's had a bit of a medical emergency at 6 o'clock this morning in Edinburgh. So we wish her well. I've heard that she's now fine, but she wasn't able to then come today. So we have Ramses Wessel, who's going to be here presenting then all by himself. He's been given a few extra minutes in which to speak. I'll introduce Ramses in a minute, but first I thought maybe just take some time to explain a bit the rationale of the question that's underlying this lecture, which is about how do we develop, or what is the rationale for a research agenda in EU performance, so looking at the EU in international relations. And I think that what you've seen over time, since people have started looking at the EU as an international actor, is a whole series of different questions that have been emerging over time. So first of all, we were looking at what the EU is. So is the EU an actor in international institutions? Right? And how does the EU then work in those? And then we were saying, what does the EU do in those institutions? And there's a whole body of work that emerged to look at those different types of those questions. And finally, we've moved on to a stage where we look at, what is the EU actually achieving? It's time to actually stand back a bit, look at what the EU is achieving, how is it actually able to do the work that it's been doing in international institutions, and how is it going about that? And that's where the question of performance has come up. Right? So is the EU a good performer in a certain field, in a certain international institution? Is the EU capable of actually running or acting in a better way to its constituent member states, or is it working in different ways to the member states? Is it actually making for a different kind of outcome that comes out of that? And I think that that kind of works as the stimulus for a lot of the questions that are being asked by certain fields or certain researchers in this field, some of them whom you will come across in the forthcoming lectures. And one of the major issues, or one of the things that's really important for us to think about, and unfortunately Megan was going to go into more detail, is actually looking at the challenges that we have when thinking about how do we actually understand the EU's role in these institutions, because as Ramses will explain, in a sense the EU has a kind of a mixed role here. Sometimes they have competence, sometimes they don't have competence to work in a specific policy field. How does that actually shift or shape the way that the EU acts in a certain way? And what kind of tools, mechanisms can we as researchers use to understand how that actually plays out and what effectiveness comes from that? So that's a bit the underlying background to this. There's been an evolution in the debate, and we are thinking now about how we go on with the debate, so looking first of all what the EU was and what the EU is, how it does it, how it achieves it, and then how do we assess performance of the EU in the fields where it does work. And that's the underlying theme behind many of the lectures that are coming up. At the end of the substantive lectures, there'll be one that covers the young researchers' perspective on this, and I see one of the co-organisers of the event, Lisanne Groen, is sitting in the audience here right now, so that's good. Right now then, I'm going to pass the floor over to Ramses, who is, as his bio says, which I have here, Professor of International and European Institutional Law at the University of Twente in the Netherlands. He's also the co-director of the Centre for European Studies at the University of Twente, and he has several other functions to add to his name. I will mention but a few. He's a member of the Standing Governmental Advisory Committee on Issues of Public International Law, member of the Governing Board of the Centre for the Law of the EU External Relations in The Hague. That's the Clear Institute in The Hague as well. And Ramses is going to be basically, he's a lawyer by background, and that's not to excuse what's coming next, but that's for information. He's going to talk about whether the EU is able to act in international institutions and what the limits are for that action. And so I'm looking forward to hearing him, and I hope you're looking forward to hearing his points on this. After Ramses has talked for about 35 minutes, we will have a short discussion where you can ask questions and answers, and I will also have some comments on Ramses' presentation. So, the floor is yours, Ramses. Thank you very much.
Thank you very much indeed, Jamal. Thanks for having me. It's great to be at the Institute again. I always love to be here. There's a number of interesting things going on. Well, let me apologize nevertheless for being a lawyer, because in settings like these, it's always a bit more difficult to find these cross-border interests. Nevertheless, that is exactly what I intend to do. I work a lot. I work at a multidisciplinary institute. I work a lot with other disciplines. I'm in a university, which is a faculty of public administration, Center for European Studies, working together with political scientists and economists and sociologists. And I always have the feeling that I'm the only one always who has to explain why what I do is important. The rest never has to do that. So, but I hope to show you that what I have to offer is indeed important for our discussion as well on the performance of the EU in international institutions. Jamal and I have been working on that project, EUPERFORM, a couple of years ago. And also I was the guy that was hired to bring the legal dimension to that project, and that happens often. I gladly do so today because I think it's very important. If we start discussing this the potential of the European Union to perform, to act as a global actor, to never forget what actually the European Union can do, what the possibilities are, what the legal competences are, and also what the legal limits are. And I hope to be able to discuss with you a few of those limits. European Union law limits, but also international law limits to what the European Union can do in the end. And we can have a discussion on that. So that's my idea, and we have a very small audience, so I assume we can have a nice discussion, sort of informal discussion, rather than a formal Q&A session after this short presentation. If you look at the treaty, and I will mention the treaty obviously a few times, I cannot help doing that, and also a few of the provisions in the treaty. But if you look at the current treaty on European Union and you compare that to the older ones, there's one thing that is really striking, and that is that the EU has become more ambitious as a global player. This is not something new. We all know that. We've been working on these kind of things. But it's really obvious now from the treaty text as well. We have a number of things in the treaty which clearly indicate that the European Union wants to be more than just something like an entity for its own member states. It's looking to the outside more and more. There are even studies claiming that the European Union is shifting away from attention to its own member states to attention to the rest of the world. So the internal market more or less is there, although we seem to be struggling with the free movement of persons these days again. More or less, we seem to be satisfied with what we have. And it's now time to move on and to even export what we have established internally in the internal market, export that to the outside. That could be internal market elements, but it could also be norms. And the normative actor Europe is not just a political science thing or an IR thing, it's also a legal thing. So the few articles here, you can see them indeed bring everything together. And if you read, for instance, Article 21, and I would even every non-lawyer to open up, encourage to open up the treaty once in a while and look at these provisions. It's a very accessible treaty, and Article 21 brings everything together, basically what the European Union can do and should do and wants to do in the rest of the world. There are many references, 19 I counted, to the United Nations. It's striking. I mean, if you look at the treaty of one organization, it refers to another international organization 19 times, including counting the declarations and protocols, but nevertheless, that's quite a lot. This tells you something about the European Union's position in the world these days. Indeed, we're talking about the international actorness, to borrow a theme or a term from political science and IR. What lawyers do with this concept is basically looking at competences. Competences for any EU and international lawyer are the key thing. Looking at my own work, I think I've never written a piece which does not somehow relate to the competences of someone. Who can do what and why? That is basically always the question. So international actors in terms of, in legal terms, always has to do with, is it the union or is it the member states that are in control? Or is it both of them together? And if it is both of them together, where then do we still draw the line between the two of them? The problem with this competence division is that it is a very dynamic division. You can put one thing in the treaty and you can say, okay, this is an exclusive competence for the European Union. Trade issues. There's not so much left for the member states. And there are other areas where there's more for the member states. Security policy, for instance, or development cooperation. More areas where the member states are in control, more or less in control. But these things may change overnight. And one of the interesting upcoming questions is, what can we expect of third states, non-EU member states, to know about this competence division? Let me take investment as an example. Investment used to be a sort of shared competence, investment policy. Since the Treaty of Lisbon, it has become an exclusive competence in the hands of the European Union. This brings about interesting questions. If you have bilateral investment treaties with third states, for instance, and you suddenly tell those third states, well, listen, we have this nice treaty, but I'm sorry, I cannot live up to my obligations anymore because I don't have the competence anymore. The competence shifted from me to the European Union. This is not the best argument to be used in international law, and it will never be accepted by third states. So here we see already something of a tension. I will come back to these tensions later on as well. A tension between being a member state of the EU and being a state, actually. If you look at, for instance, some of the case law of the past few years, you see that member states or states being a member of the European Union at the same time seem to be forced to be a member state first and then a state. So they have lost a lot of their, if you want, statehood. If there's a conflict between a European Union law obligation or an international law obligation, the European Union will always tell the member states, well, listen, it's us first. You first have to look at the European Union and then look at what else you want to do as an individual state in the world. Of course, there is a tension there. And it also comes back in the identity of the European Union itself. Of course, this is the classic question, what exactly is it that those states are a member of? Is it an international organization, or is it something else? And political scientists have come up with interesting ideas of a polity. New words are being invented. Lawyers would normally say, well, we're not really sure. It's something sui generis. But I always force my own students to make that choice. What do you think the European Union is? Is it an international organization, or is it a state? Because in international law, there are not so much different categories. It's either a state or an international organization if you're talking about a legal entity. And if you then look at the European Union, it's probably easy to answer, at least for lawyers, but we can discuss that as well, that it is still an international organization. The reason being that it's not a state. And it's not a state because we still have the member states as entities there. This, of course, this complex situation of being part of an entity with a sort of fuzzy, or at least a very special identity, is also confusing for the rest of the world. And, as we will see, is also confusing for other international organizations. So if we are discussing the performance of the European Union in other international institutions, this issue always comes up. We'll have some examples of that later on. But one obvious example, of course, is the whole discussion about the EU's presence at the United Nations. Over the past 2-3 years, and even longer if you go back, we had discussions on how the EU could be presented and present at the United Nations General Assembly. Now we've found some kind of compromise. It's not a state, it's not just one observer international organization, something in between. Now they have gotten this sort of in-between status at the UN. And now it is indeed possible, formally possible even, for the European Union to speak during General Assembly UN conferences and meetings. The problem with this not being a state, but still being an international organization and having these ambitions in international law, has its repercussions on diplomatic law, on international diplomatic law. And this is just a quote from a colleagues actually of mine in Leuven, Jan Wouters and Sandrine Duquette, who wrote extensively also on these issues. The emergence of the European Union as a non-state actor in the diplomatic arena shakes the foundations of international diplomatic law. That is something. We have an entity now that has all these global ambitions. It wants to be a global actor, and it seems to shake up, indeed, the world of diplomatic law because it does not really fit in. And that is an interesting element. I will come back to a few elements also later on that issue. At the same time, we see that the European Union is developing, trying to mimic, in a way, statehood. Well, the European External Action Service, of course, is a very fine example of that. Could it be a foreign ministry? If you look at what it does, it basically is something like a foreign ministry. And not just the parts that are here in Brussels, but also the parts that are abroad, the union delegations. EAS, taking care of all the foreign relations, preparing not just the speaking notes for the council and for the commission for Mogherini, but also for Tusk, for instance, Donald Tusk. So it's basically preparing foreign policy for the entire European Union. It's assisting the European Parliament. It's assisting all the other institutions. So here we see something that is in Brussels developing like something like a foreign ministry. And that is particularly interesting because the member states are still at the background. You may know this entire discussion of Mogherini moving her office from the EAS building back to the Berlaymont building. And now she's together with the other commissioners in the Berlaymont building. Well, there are many member states who were saying, well, is this really a smart move? Of course, in consistency terms, it makes sense for Mogherini, who is both the Commissioner for External Relations, but also the more, if you want, intergovernmental High Representative for EU foreign relations. It makes sense for her to combine what she is doing in the Commission with her fellow members, with her fellow commissioners, and being in the same building. Yet, it's quite a move for the High Representative of Foreign Policy, who was there basically on behalf of the member states, to make that move to this scary supranational commission, in a way. And you see that member states from the outside have been sort of nervous about these developments of the European Union. You see Declaration 13. At the back of the treaties, you have these very interesting declarations. To a political scientist, they may make sense. To a lawyer, they normally do not make sense at all. This one, the establishment of the EEAS does not affect the responsibility of the member states, as they currently exist for the formulation and conduct of their foreign policy. Does not affect the responsibilities of the member states. Yes, of course it does. It does affect the responsibilities of the member states. The whole purpose of the establishment of the European External Action Service was to do something else, to do something new, and it has affected the responsibilities and the things that the member states did. So you may put something in a declaration, but look at the declaration again after a couple of years, and you see that it did not really make sense. Declaration number 14. The External Action Service will not affect the existing legal basis, responsibilities and powers of each of the member states in relation to formulation and conduct of its own foreign policy. Well, it did certainly affect all those things over the past few years already. And we may have a discussion on whether that is mere coordination between the member states when they operate outside and in international organizations. As you can see, it's participation in international organizations is mentioned as a key thing in this declaration. But looking at what happens, I mean, there's something going on. The EAS has a lot of personnel working on things, and they're putting forward proposals and tabling proposals. So they are affecting foreign EU foreign policy, and they are affecting the foreign policy of the member states. I mentioned the European Union External Action Service, the building here in Brussels. That's starting to look like a foreign ministry. Even if you enter the building, I mean, you have the feeling that there's something going on there. And also, foreign representatives are visiting that building and having their meetings there with Mogherini, for instance. But even more interesting is the part of the European External Action Service that is outside Brussels, and that is the union delegations, of course. Union delegations not just in many of the third states, but also again at some of the international institutions, the key international institutions. There's a union delegation. And indeed, this is the first time that we see that the European Union as such has created these union delegations. No longer just extensions of one of the institutions of the European Commission, but this is the European Union being present, being visible everywhere throughout the world through these union delegations. And one of the things we found out in doing some research on these things with a number of colleagues is that they're really starting to look like embassies. And just one of my younger researchers did a sort of comparison between union delegations and national embassies, and the similarities are striking. I mean, they operate similarly in many respects. Ambassadors, as we will see later on also, ambassadors are being appointed at union delegations. So they're not just called, as they used to be, the head of the delegation or something. No, they call themselves ambassadors, which is an interesting psychological thing, of course. And of course, they're present at all the embassy receptions, etc., alongside the state ambassadors. They participate in that world. And you have these letters of credence, which are normally sent by the head of state to another state. Would you accept this person as my ambassador? And these things are also sent by the European Union. The problem is, again, that the European Union is not a state, and that the European Union is struggling with these different identities. I mean, you have these supranational things in the hands of the Commission. You have the more intergovernmental ones in the hands of the High Representative, Federica Mogherini at the moment. And of course, there's somebody who is called the President of the European Council, which is now Donald Tusk. So you see, just taking one example from one of those letters, you see how they solve those issues. They make these very complicated sentences. On behalf of the European Council, President Herman Van Rompuy at the time, and the Commission and President José Manuel Barroso, and under the authority of the High Representative Catherine Ashton. So all of them have to be included somehow. Whereas normally you would have one head of state. In the European Union, you're still struggling with, yeah, but I also want to be there. And if we simply take Herman Van Rompuy in this case, then it would be too intergovernmental. It would be just the European Council. If we just take the High Representative, then the Commission would not be there. So you see, the struggle is everywhere throughout this whole process. The same holds true by, if you look at, for instance, if there is a union delegation at the United Nations, and there is one, it gets instructions from different sides. Normally, the state delegations at the United Nations headquarters in New York, they get their instructions from their own government. Here, the union delegation gets its instructions from both the High Representative and from the Commission, and it's up to the head of mission to sort of make sense of that. Again, this is not new. I mean, we've seen this before with these special representatives and special envoys. They may get instructions from different sides. But here it's even formalized. It's formalized in the treaty these days that they get instructions from, and in the EAS decision, they get instructions from both sides. Then, of course, the European Union has to make sense of that. And what they do then is conclude these interinstitutional agreements again. So how are the three or sometimes more institutions working together? And they need another interinstitutional agreement in Brussels to make that work, to not confuse the system too much. And it all has to do with this tension, inherent tension between being an international organization, but still you have the member states there that also want to have some influence on all of these things. Jamal, you're going to stop me when I'm going over time, right?
Just checking that.
Yeah, good. Good. So there is a tension, and there's also, it's especially, I think, this tension which I want to bring to the fore, and which we're going to discuss the research agenda, which I propose later on. This is very much behind all of this. The tension between what the European Union wants to do. It wants to be a global actor, also in other international institutions. But we still have this international and EU legal framework that somehow seems to limit things, but also may offer some possibilities. I mentioned a couple of things here that may give you some idea of that. VCDR and VCCR stand for Vienna Convention on Diplomatic Relations and Vienna Convention on Consular Relations. Those are the international agreements on the basis of which we have regulated all the diplomatic affairs between states. The European Union obviously is not a party to any of those agreements because it's not a state. Yet it wants to act like a state. It wants to be there and have all these diplomatic relations. So what the European Union simply did, it sort of incorporated all those rules that existed between states into its own system. So if you would see a headquarters agreement between the European Union and the Union delegation in New York, for instance, you would see that it mentions, yes, we accept all the rules from the Vienna Convention on Diplomatic Relations, although it was made by states and for states. So basically what they do is incorporate an entire package of law which was made for and between states into their own system to allow the European Union to function almost as a state in the world. Well, those are the establishment agreements. They are concluded. Another example is they have full diplomatic immunities and privileges. So union delegations, union delegation ambassadors in a way, have a sort of similar status in those host countries as national ambassadors. There's a lot of things about symbols, so they can have the flag and they can have a hymn, whatever. So you see these state-like symbols, they can also be used by union delegations. They can wave their flag and they have all kinds of rules on that and agreed on those rules. One of the problems they're still struggling with is the passport thing. Diplomats normally have diplomatic passports, so you can easily access certain areas or go through the airports quite quickly without being disturbed, etc. Normally, European Union diplomats don't have a diplomatic passport although they may have one from home if they happen to be a national diplomat at the same time. So they had to come up with all these kind of tricks to deal with that. And they did that in the form of what is called a laissez-passer document. But the problem with those things is, while diplomatic passports have been accepted by everyone throughout the world as a diplomatic passport, you have to convince each and every third state every time that a laissez-passer is also a valid thing. And you need negotiations on those things with each and every individual country. Okay, this is like a diplomatic passport. Please accept this person as a diplomat. And it's simply because the EU does not fit into that system, and yet it has to fit in to be able to play along with the states in a way. This is all, you can call it a copycat effect in a way. It's sort of mimicking, the European Union is mimicking states, and it has a reason to do that, because it has these global ambitions, it wants to play in the world, it wants to be present at other international institutions, and yet it's not always possible to do that. But you see here, and this is just a quotation from one of those letters, and in this case it's one of the speeches actually given by the Union's ambassador to the delegation to the US, as I assume the role of European Union's ambassador. There's no shame anymore. People simply say, I am the Union's ambassador. This is a state-like term, but it's used by these ambassadors, heads of delegations these days. All right, so what lies behind all this is what I mentioned in the beginning, that is the competence division. The competence division between the Union and its member states. And it's becoming more and more problematic. It has always been a problem, but it's more and more problematic because the European Union, the more it does, the more competences it needs. This is the political science, neo-functionalism heritage that we see here. You start with something and you sort of use a competence, and which implies that you also need another competence to do that. And member states see this happening. They see the European Union moving forward, and they see their own competences being limited more and more. But this is how it goes. I mean, this is all in the game, unless you simply at a certain moment say, okay, this is the limit, here we stop. But it's almost impossible to do that. This results in, of course, the famous mixity thing. Mixity stands for instance, mixed agreements that are concluded by both the European Union and all the member states. But if you look at those mixed agreements, sometimes there's only a small fraction left for the member states. So all of them, all 28 of them, still have to sign those, for instance, trade agreements. Because there's still something left which belongs to their competences. So we can have a discussion on TTIP, for instance. Would it be necessary to have it signed and ratified by all the member states? I mean, it's about trade and it's about investment. Both trade and investment are almost fully, in the hands of the European Union. Member states do not have anything to say about trade and investment anymore. So why do member states still sign these things and have all the 28 parliaments have to say something about that? Well, that is probably end up like a mixed agreement, because they found something, but that still belongs to the member states. So there may be a small chapter or a small section or even just one provision which is still in the hands of the member states or is shared with the European Union, which allows the member states or even forces them to be co-signatories to these kind of agreements. Of course, that's complex. It's complex for the rest of the world as well, because they want to deal with just one entity. The Commission has been negotiating these kind of things, and now they have to wait for 28 member states to sign and ratify these things. And some of the member states may even want to have a referendum on something. So you have to wait for another year or two. So you see the complexity here behind this thing. And, as we will perhaps conclude in the end, this has an effect on the performance of the European Union. This has an effect on the performance. The European Union simply not able to act on its own because there are still competences that are shared with the member states. So we have a number of developments here. If you talk about representation of the European Union in other international institutions and during international negotiations where you have similar things. Let me just mention, I will not mention anything more, but just two cases of the European Court of Justice, two recent ones, which somehow affect, again, this role of the European Union. There's an ITLOS case, I will not go into detail. ITLOS is the International Tribunal for the Law of the Sea, which deals with all the disputes on the basis of the International Law of the Sea treaty, to which the European Union, by the way, is not a party, but the member states are. And nevertheless, the European Union has a number of competences taken away from the member states in the area of the law of the sea. So you have a difficult situation. Member states are a party to a treaty, but they in fact lost the competences over the years to the European Union. But the European Union is not a party to a particular treaty. It's not just in this area. You see that in fisheries, for instance, where member states can be parties to a number of the treaties and the European Union not. But the member states are sitting there without basically having any competence. So this is a sort of strange situation where you have to find solutions. And here it was about basically, can the Commission represent the European Union? In this case, well, it's a complex case, but in the end, the court said, well, yes, the European Commission can represent the European Union. Doesn't necessarily have to be a member state. The Commission can do that. So you see, this helps the Commission. This helps the European Union of becoming more visible in other, in this case, international tribunals. So sometimes the court can help. Commission versus Council, another recent case this year, was about does the Council always have to be involved in all these negotiations? Normally the Commission negotiates all these agreements, gets a mandate from the Council, so basically from the Member States. So to what extent does the Council need to be informed in detail about what is going on? Well, again, there's a lot in this case, but one of the things that came out of it is that the Commission can basically go its own way. It doesn't necessarily have to inform the Council on all the details during the process. But just in the beginning, you have a mandate, and in the end, you come back and you keep each other informed, but not on each and every step that has been taken. Again, you could say, okay, this is helpful for the Commission. It's helpful for the European Union to act on its own, more or less, rather than just being dependent on each and every member state all the time. Because during those Council discussions, of course, each and every member state can always try and block and disturb the negotiating process that you have with another state. Am I still fine time-wise? Yeah? Okay, it should be fine. Another problem is that if you talk about the EU in other international institutions, it not only depends on the competences of the European Union itself and of the competence of the member states, but also on the other institution. Does it allow another institution to become a member? So we have seen that the European Union can be a member of some of the other international institutions. But in many cases, if you look at the constitutive treaties of those organizations, it said all states can become member, blah, 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 blah. United Nations is a very good example. All peace-loving states can become a member of the UN. It doesn't say, and all peace-loving international organizations also, by the way. No, it doesn't say so. So it's just states that can be a member of many international organizations. The WTO, World Trade Organization, of course, is a very good example where the EU is a member, a full member, has been a member from the outset, and is a very active member, and is in fact, here the question is in fact interesting, why the member states of the EU are still a member of the World Trade Organization. Because basically it's about trade, and as we know, trade is an exclusive power of the European Union. So the member states are there in Geneva at the WTO, basically, I guess, having lunch and nice discussions, but without not so much to say anymore these days. I already mentioned the difficult legal things when you are a member as a state of a particular international organization, but you have lost everything. And sometimes the union has taken over those things. And by the way, let me just say one thing about that. In some instances, member states have to act as agents of the European Union. Because they are the ones who can be a member of those international institutions. The European Union cannot. They don't have competences, so their competences at that moment are not their own competences anymore. They are derived from the European Union. So they act as agents of the European Union in particular international institutions. Again, a very complex thing that of course affects, again, the way the European Union can act in those organizations. There is one problem lying behind all this, and that is what we call the autonomy of the European Union. The European Union has been called by itself, by the court, from the 1960s on, an autonomous international organization, which has its own legal system, which is sort of disconnected from the rest of the world. We have our own rules. And that has its effect on what is called the exclusive jurisdiction of the European Court of Justice. So, when we are talking about the interpretation of European Union law, rules, decisions, whatever, there's only one court who can say something about that. That is the court of the EU itself. That makes it difficult sometimes for the Union to be a participant in other international disputes, because in the end, the court will preserve and protect its own autonomy in that sense. Very good example, of course, was the recent example of the accession of the European Union to the European Convention of Human Rights, which was a thing that was prepared over many years. The European Union has tried before, that there was no competence at the time in the treaty. So the member states said, okay, let's then introduce, in the next treaty revision, let's introduce a competence, or in fact, an obligation. And it now says, the European Union shall accede to the European Convention of Human Rights. Shall accede. Sounds like an obligation, right? So there's an obligation for the European Union to join the European Convention of Human Rights. Sort of makes sense. If you keep in mind that many of the competences have been transferred from the member states to the Union, so member states are no longer accountable for many of the things they do, also in human rights terms. So then the entity to which the competences have been transferred should be accountable for human rights. So that's why the European Union should join the European Convention of Human Rights. The whole thing failed because the court, in opinion 213, said, well, basically it boils down to the idea that no, we think this is too tricky. The Human Rights Court in Strasbourg will then tell us something about the interpretation of European Union law and a few other things. And we actually don't like that. And basically, the court said we are the only ones who can deal with this with our own rules. If any state would say something like that, trust us, we know what we're doing with our human rights, we don't need a human rights court, we would probably say, well, yeah, in that case we probably will not trust you if you say something like that. In the European Union case, well, this is exactly what the European Union Court said. We are able to do this and we don't want any interference, at least with our own domestic legal system. Coming to my final research agenda slide. Thinking about Jamal's request of coming up with a number of themes from my own perspective, which should be part, I think, of a research agenda for the coming years. If we talk about the position of the European Union in the world and in international institutions in particular. Linking, indeed, politics and law, which is something I like very much. You could come up to at least four things. Let me briefly mention all four of them. First of all, linking political performance and legal competences. We have done many studies on the political performance of the European Union. How are they performing in international institutions? That remains a very interesting thing. We should continue doing that. What is missing is linking that to what can the European Union actually do? Is it competent to do that? Or is it restrained by certain legal limits in that respect? So if we combine what the European Union can do to what it actually does, you would have a new point in the whole discussion on the EU performance. Secondly, linking political ambitions and legal possibilities. So you have all these ambitions of the European Union. The European Union wants to be a global actor. It wants to be present in the United Nations. It wants to be present in many other international organizations. And again, can it really do that? And then extending that question also to international law. To what extent is it possible for a non-state to participate among states and to play along, if you want, with states. There are, both from an EU and an international legal perspective, there are limits to what an international organization can do if it is not a state, and yet has the ambition to play along with states. Thirdly, linking actor performance and legal provisions. Legal provisions, by legal provisions I actually mean things that are in actual decisions that are being taken. Sometimes you have a performance based on a policy document, whereas at the same time the European Council or the Council has issued a sort of other decision. What is in that legal decision and what is in the policy document is almost never compared. And it can tell you something about the possibilities of EU performance. And it's very much linked to the final one. Also, look at international agreements. Actually look at international agreements that are concluded. What is the role of the European Union in those international agreements compared to what you want them to do politically or from a policy perspective? Again, if you would lay side by side a policy document of the European Union, this is what we want to do in climate control. And at the same time, you would look at the international treaties and conventions that have been concluded in that area. Compare the two and see if there's a relationship between what they can do or what they cannot do and what they're actually doing. I think that would be already something that would be gained by this research. Thank you very much.
Thank you.